Good evening. Thank you very much for being here. I'm reconvening the August 4th Board of Supervisor regular scheduled meeting. Just to let everyone know, Supervisor Smith is out of town in Colonial Beach, but joining us by Zoom,
Yep, personal reasons.
personal reasons.
That's correct. Thank you.
All right, we did not have a closed meeting, so I will go ahead and open public comment. Anyone wishing to speak, we are going to limit it to 5 minutes. And if you'll give us your name and your district, I'd appreciate it.
Karen Hunt, Jackson District. Regarding the sign ordinance and specifically public art murals, I personally like art. Not as good at it as some people. Some of it I don't get, but I appreciate those with creative instincts and expression. That being said, I'm feeling more and more that it would be a big mistake to create a carve-out for art. The proposed definition of any item expressing creative skill or imagination in a visual form intended to beautify or provide an aesthetic influence. It's so subjective. Art by its nature is subjective and open to interpretation. That's so broad that it could include many things most people might consider to be a sign. And I understand that art, murals, and other forms of creative expression, it's a complex subject. However, if we adopt what amounts to a blanket exemption without any limits on size, duration, number, or design, it will create a giant loophole that someone, perhaps with an axe to grind, could exploit to the detriment of the whole community. It puts a huge burden on the zoning administrator to try to interpret what that is, given the subjectivity. And I'm just concerned that that could set the county up for future legal situations. There really need to be some limits, and not quite sure how we do that, but I urge the board to consider addressing art, maybe in a separate art mural or some other provision, but not a blanket carve-out. Thank you.
Thank you.
Laura Grigsby, Hampton District. In the last couple of months, as I sift through things that I'm learning, a lot of things seem to be coming from grants or special considerations from the state or something here and there. And I'm getting very confused. And it would be really, really helpful, and especially I had a conversation with a very particular representative, not here, concerning grants. If it could be denoted, if this money that's being brought into the school or into the county or into going into a very large project like the courthouse, if there's grant money that's being brought in, if that could somehow be denoted, because here's my concern, and I've already expressed this concerning having an assistant district attorney in this area, is that once these things get started, whether they start from a grant or from somewhere else, being a special allocation from the state, when they go away, all of a sudden they're our responsibility because people continue to expect them to go on. And an example, this past summer or during this summertime, there's a lot of redundancy that goes on that I'm seeing at this point, because right now you could send your kids under 18 to the school for breakfast and lunch. And then on Wednesday, you could go to the library and pick up a box of food for each of your children under the age of 18 through the Blue Ridge Food Bank, which I'm not really sure why a food bank that's in Harrisonburg would be bringing food over here unless the planning district's changed, and I wasn't aware of it. But you could you could pick up 5 food stable breakfasts or shelf stable breakfasts and 5 shelf stable lunches for every child that was there, even if they already ate at the school. And then, I'm not completely correct about this, but I believe you can go on Thursday, if you have kids under 18, and get a backpack of food to go through the weekend. This seems like a lot of redundancy to me, and that we're not communicating to each other. And believe me, I want every kid that's possible to be properly fed. I want them all to have clean clothes and a nice warm bed to sleep in, or a cool bed, depending on where you live. But it just seems like we're duplicating many things in many places by well-meaning people and well-meaning organizations, and we're not looking at where all this stuff is happening. And we're creating an environment, in my never to be humble opinion, that expects these things to keep happening instead of having some personal responsibility. So, thank you.
Thank you.
Mr. Barr?
Yes, ma'am.
Hi, Sheila Gressinger, Hampton District. I'd like to just have a little bit of fun, sort of. I know at the last meeting, we were talking about educating our public about the necessary courthouse, why we need to have it. And actually, the very interesting thing was just this past week, there was an article in the Wall Street Journal, and it was how to make an impression. And it's a book about speak memorably as how to how to captivate an audience. And so this is going to be sort of complicated. Anyway, last week I did a commentary in the Rap News, and it was thinking outside the box. Unfortunately, a lot of it got eliminated, I think probably because of space limitations. I was talking to my daughter about it, and she said, Mom, the essence of it was still in there. And I said, well, the essence was humor, and that was deleted. So I'm going to help you understand what I was talking about. When I was talking about finding money for the courthouse, there was an expression, there's gold in them thar hills. And I also said in the hills and in the valleys. And then I gave an example as recommended by this article, which was sort of interesting. Back when I was an advertising rep, I was working for a newspaper. And one of the other people took me for a ride to show me my territory. And as we were driving down this one major highway in Fairfax, he pointed to one side of the road that had all kinds of businesses and shops, and he said that was his territory. And then he pointed to the other side of the road, and it was woods, and that was my territory. So when you're thinking about the expanse of Rappahannock County with all the woods and the valleys, I found gold in those woods and other places, and I was able to make a successful career while I was at that newspaper. So I know there are ways that we can find money to fund a lot of these projects that we have. The courthouse is one. Eventually, I think the library is going to be another one that's going to be very important. But the whole thing is communicating by educating and by giving examples of what can be. Okay. In this article, they said one of the ways to do this memorable thing was to use storytelling or to have anecdotes and everything. So one of my examples is, I think with all the news that we've had in the Rappahannock News, which has been absolutely wonderful, and we've had the website, which has had all kinds of information, we've had board meetings, and still there are some people who don't understand the importance of our courthouse. And I think perhaps it could be something that the board or the county could establish, say, a set of articles in the newspaper with some kind of concrete examples. And one of the things that was in last week's newspaper that was very good was Connie Compton talking about that incident that was outside the courthouse, talking about safety. That was in the newspaper, but it was on like a back page. I don't think some people read about it. And there was also a part where Art Goff was saying that because of the out-of-town people there's more work to do with our courthouse, and that our courthouse really isn't able to handle as well, or they're overburdened and everything. So that's very important as well. So, okay, so this is funny. So also in last week's paper, as I was saying, here's all this stuff that's been in the paper and everywhere. So I was almost speechless. I told my husband, speechless. He said, Sheila, you speechless? And he about fell off the chair. But it was this comment that this lady, I don't know if it's a lady or a man, because there's just initials, but they're saying that the judge really shouldn't have any say. Who is this judge to say that the courthouse wasn't safe? What kind of OSHA qualifications did that judge have? And did this judge want to have a new bench, a new office, a new bathroom, a new cloakroom? She didn't think that's a wise expenditure of her tax dollars. Oh my goodness gracious. That's why I think it's so important that we pay attention and start putting some articles as features in our newspaper to let people know, using some of these examples to let people know. And I think that would just be a very important and very wise decision, and I hope we can follow it, because I really want to see that courthouse. Thanks.
Thank you.
Thank you, Sheila.
Diane Bruce, Berryville. What is CAO? Is that County Administrator Office?
Chief Administrative Officer.
Okay, and that'd be you?
Yeah.
Okay, thank you. I was kind of surprised to see this line item about the construction in the town of Sperryville going over the boundary into the right-of-way, and that VDOT will have to follow up on that. Who would be responsible for having let that happen? Who should have caught that so it didn't happen?
This isn't a two-way conversation, sorry.
Well, maybe we can follow up.
Absolutely.
So Ms. Bruce gets an answer.
Yeah.
What the process was, maybe.
Yep.
Sure.
All right, not seeing anyone else in the courtroom, I'm going to go to Zoom. Anyone wishing to speak during public comment, please raise your Zoom hand. Not seeing any Zoom hands, I'll close public comment. Did you want to address the question?
If you'd like me to.
Yes, please.
Generally, for a commercial establishment, depending on whether it's a by right use or a special exception use, they go through different pathways. Special exception or other uses might require a site plan, and if it were detailed enough to show the wall in a survey, it might be caught. In this situation, the individual surveyed the site and then built the wall where they thought the line was. VDOT surveyed the site and has a conflicting survey, and after the fact, the wall is actually over both lines. But it's a civil matter really between the owners and VDOT, because the owner's survey wasn't good when they staked out their wall. So nobody approved the wall in the right of way, they just built the wall where they shouldn't build the wall. I don't know, if that makes sense.
And does our building department ever check stuff like that?
A building department would never. Zoning might, but there's no setbacks for a fence or wall or anything like that. I think they took the presumption that the sidewalk was built to the edge of the right-of-way during that old TAP project, and apparently it was built on a variable distance away from the right-of-way, you know, from 0 to 1.5 feet over the length of that area, which is a little odd, but is what it is. Maybe they did a survey back then, it was different yet again.
So I wonder, they hired a surveyor, right?
Well, there's an agenda item tonight. so
Yeah.
Okay. Moving into old business sign ordinance, continued discussion.
Sorry, didn't advance So the board had been moving through sections of the sign ordinance at a pretty good pace, meeting to meeting, and then we ran into a series of meetings when there was very busy evenings. So it's been on the side burner for a little while because there aren't a series of public hearings tonight. It's back. The board's already discussed temporary signs, off-premise signs, animated signs, and the next item on the list was public art and murals.
Is that our focus tonight?
That is your focus. That's right. When the draft sign ordinance was initially prepared, Art and I kind of went through and put up a draft for consideration by the planning commission and board. It included a new article for public art with the intention of being able to regulate public art, the items that your public speaker mentioned, basically how big you want them, where you want them, and how long you want them. And after some back and forth with public, including representatives of RAC, the community suggestion at that time was, well, I don't think we really want to regulate public art, and we should just exempt it, which is really the other way it is considered in the model ordinance from the Local Government Attorneys Association. I attached that LGA model, which doesn't include a ton of information. So the current version that has been contemplated by the Planning Commission and Board is written to basically carve out public art from the definition of a sign. So sign specifically does not include public art, so therefore we don't regulate public art. And it's very complex. If art is very much in the eye of the beholder, and whether you choose to permit it or choose to carve it out, there is always a subjective line between what it is, what it isn't, how it's going to be regulated or not. Either way, and a zoning administrator, human, is going to have to identify whether that thing is a sign or not, and that human is going to then make a determination, and then there's an appeal process that can go through the BZA and into the courts. Either route you take. So I believe that the really core essence of the issue is, do you want to regulate where and how big these things are? Most of these are not temporary signs, so it's really where and how big. And if you want to do that, then we should take an approach that is not carve it out, define it as a separate thing, and then say it can be a maximum size of whatever, and they can only go in certain zoning districts or certain distance away from the road, or whatever you kind of dream up that you think has a safety nexus, because you don't want to confuse somebody. There, like I said, there'll still be that gray line, because as I wrote somewhere before, we all know that when we look at a side of a barn and it's one color, that's not art. And then it's two colors, and then two colors that are like shaped in different ways, and now you have 3 or 4 colors. Somewhere in that continuum, it turns into art. And so how many colors are you allowed to paint the side of your barn? And in what shapes and sizes? And do we really want to be in that business? And once you jump into that, which is fine, I mean, we can do that, we don't control that message at all, just like with a sign. So it might be art that you think is really beautiful and bucolic, and it might be something entirely different that is on the edge of obscene but not obscene. And that would be the reason why you might want to try to regulate the size and the location. But someone still has to look at it and say, sign, art, and pick. And I don't know how to make it any more.
How do you feel about that, Mr. Goff?
Well, I think what Gary said is well taken. It's the safest route is to, and I think you would probably want to allow such a thing. The Welcome to Sperryville sign is a great example. So size and location are the safest things to regulate, not the content, obviously. I was thinking while Mr. Curry was speaking about hex signs up in Pennsylvania.
Yep.
And what is that? Is that a sign or is that art? Well, I think they're art, but and they're traditional.
Yeah.
So there's stuff like that I think is best allowed. Just carve it out and say, if you're going to have public art, this is how big it ought to be. So go to your biggest barn in Rappahannock County and look at it and say, do I want this whole thing painted with a hex sign you know,
What is
a
that? I'm
mural.
sorry.
Oh, it's like the,
Sign-
No.
Oh, it's,
like on Barnes.
it's an old German tradition.
Like the quilt thing?
It's
Well,
like a
kind of,
quilt,
it has that
and
pattern.
it's usually
Really pretty.
circular,
Yeah.
but sometimes it's square, and they put it on the sides of barns.
It's like a
People-
family crest.
No, it's comes from Silesia, I think, or North Germany, where these immigrants from Germany.
You see it in
came.
Wisconsin
Century
a lot.
was their tradition, and I don't know if it had some sort of superstition with it or not, but they're all over the Amish area around Pennsylvania, eastern Pennsylvania, and they're in the Valley of Virginia too.
Yeah.
So wherever those the immigrants came down the Valley Pike, that you'll see them, and some of them are quite beautiful and intricate. So is that you want to call that a sign? It's called a hex sign, but it doesn't advertise anything.
No.
It just wards off evil spirits or something like that. And so that's a place in a place like Rappahannock, because we're rural. I had one on my barn for a long time. So anyhow, what Mr. Curry said is correct, that you're allowed to regulate the place and the size, just not the content. So if you're gonna allow it, it should be exempted from the sign ordinance and just have a size limit to it, and if you're so advised, a time limit, but most of them are permanent. So I think what Gary said makes a lot of sense, because he's right, that somebody's gotta make the decision. Is it public art? Well, if the neighbor comes in and says, no, it's a swastika, and it's a political advertisement, then, we'll have to cross those bridges, and that's what judges are for. Once you get into the situation where a decision has to be made on who's right and who's wrong, that's why we have the very civilized system of going to court, so that there is a judge who's objective and will weigh all the factors, apply the law, and come out with a decision. Litigation is not always something we have to run away from. And the likelihood of it, especially given the fact that most people with private property don't want to diminish the value of their own property by putting something permanently noxious there, I think is just a natural market force countervailing argument against having to be so upset about it. Plus the disapprobation of their neighbors and fellows if they put the swastika on the side of the barn. Who's gonna go to their dinner parties?
All right.
Okay?
Like-minded people.
A certain group of people maybe. I mean, my view of this is kind of, when on temporary signs, Van really thoughtfully came up with sort of a scheme, but sorry, I'm trying not to turn my back to anyone here. Donna. But Van on the temporary sign part of this discussion very thoughtfully came up with, if I recall correctly, different seasons, different zoning districts, different sizes. And I think, like a lot of things in Rappahannock County, if we come at problems from, here's our county attorney and here's a model ordinance, oh boy, we better really get serious about this and really come up with something that's enforceable. And sometimes we get carried away and lose track of the obvious, which is this county is not exactly dominated by public murals all over the countryside. And I think Art makes a good point. It becomes a self-countervailing or self-regulating scenario where people don't want to pollute their own property. So for whatever it's worth, I'd like to address this with a very light touch, which seems to lead us to carving it out and then some reasonable size that allows people to be artists and be done with it. I don't know why we would make it overly complicated. And I know, for example, in the town of Culpeper, there was a beautiful mural just restored by our local artist, Tom Mulaney, and it was the size of a side of a building.
Two-story at least.
Yeah, and it's fantastic.
Yeah.
It's fantastic. And to think about the talent we have in this community and people of great taste and great artistic talent, the last thing I want to do is, like, pardon the expression, get my undies in a bunch about over-regulating this, It's, let's acknowledge that this is a beautiful rural place with a lot of talented artists, and just make it reasonable. And it seems like some size, easily enforceable, not with all kinds of, here it's this and there it's that, but maybe some maximum uniform size within reason, maybe commercial is different than ag, and leave it at that. It's,
That line between commercial and non-commercial is sort of blurred down.
oh, that gets into Reed
after
v.
Reed v. Gilbert.
Okay.
Gilbert, yeah, that's.
I meant
that's sort
zoning,
of-
I meant zoning district, I meant
Okay.
zoning
Those are
district,
in.
yeah.
It was that Wagmore Dogs case where they put their,
Yeah.
kind of, next to the dog park, they had this nice scene, but then one of the dogs was their mascot or whatever.
Oh,
What do you call it? Iconography for their company.
Trademark.
Trademark, something, and it was like, nope, can't do that, that's a sign.
So,
Which we would have all those controls available to us, as a zoning administrator is looking at this wonderful art piece saying, it's commercial, that's a sign, that's a different
Yeah.
size. And we're gonna take you to court over that, or ask you to resolve it peacefully.
so I agree with Mr. Whitson here. I think that, I'm just thinking what we currently have. Mr. Goff mentioned one, we have one at the rec authority on the fence,
it's beautiful.
which you can see from the road.
There's a few in Sperryville.
There's one on the side of the, high school.
Yes, a couple.
Uh,
And they have to be viewable from the public realm.
which you can.
Yep.
And I agree. I think it's, they add to the community. So the question is what is the latest iteration of this carve out? Do we have it of the size?
There is no, right now, it
There
simply
was never
says.
bandied about, never.
No, the current, the initial version got really in the weeds on regulating what, all kinds of constraints on public art murals. Public art can also be a 3D
Sculpture.
sculpture or something, right? Currently, the current iteration is simply, here's the definition of sign. All these words, public art is not a sign.
Right,
End
I
of,
remember
end of
that,
story.
yeah.
And so that means it can be any size, anywhere. It's not a sign, you can paint your barn any number of colors you want.
And we said you just can't have writing like,
Well, that
This
goes
is
back
my
into,
store.
right now, like today's definition gets really confused because it starts talking about words, which words aren't necessarily commercial speak when they say, welcome to Sperryville, or have a great day, but if they say shop at Roy's, now it's changed. Right?
So I'd be comfortable just kind of setting a limit on the size and moving forward.
Yeah, I agree.
But I'd like to hear what, Ms. Smith, if you have any thoughts, you've worked on this as long as anybody, so if you have thoughts.
Yeah, I don't really know what size would bring to the discussion. I think that we might just be setting ourselves up for, future claims that was sort of arbitrary, unless we can find a way to get our arms around it.
Am I hearing like, a sign advertising the bookstore is limited to X 35 square feet or whatever it is, 100 square feet, yet the mural can be 500 square feet? Why the disconnect? Why is one safer
Right.
than the other?
Well, and just in general, like if you have a smaller building versus a big building, but they're both allowed to have the same size mural, it just seems like it gets very convoluted quickly, and there could be a couple of ways to slice it up as arbitrary.
So you'd be in favor of not setting a sign limit and just having a carve out?
I don't really, I think by the time you navigate the waters on how big or small it's gonna be, you may have created more problems than you solved. You may tell someone what the maximum size is, and they may decide to go smaller. Or bigger, I'm sorry, with max sizes, and they may decide to go bigger than they were originally intending to. So, but if y'all wanna, impose a size, I mean, I'm sure it can be done.
Christine, it's Kier, in case you couldn't tell from my resonant voice. would you be comfortable just, since you're remote, as I hear from you, would you be comfortable just going carve out and then we put it to a public hearing and be done with it? I mean, we're not.
Yeah, I was surprised we were reviewing this again. It seems like we've reviewed this so many times.
I think we're just
And
checking.
I did just want to revisit the language because, of what Ms. Hunt said in, her statement at the beginning. My memory is that there is a line that it makes a clear distinction between commercial and versus art. You're trying to navigate remotely, I'm a little bit fumble fingers, but I just want to revisit what is the distinguishing language there.
Hopefully you can see it on your screen now. And I don't know how you want me to try to read this or what do you want?
Sure.
So the definition of signs is picked up from one of the LGA examples. Any writing, letter, or numeral work, pictorial presentation, illustration, or decoration, emblem, device, symbol, or trademark, flag, banner, sculpture, or any other device, figure, or similar character that is A, used to direct attention to an object other than the sign itself, person, institution, organization, business, product, service, event, or location, or to announce, identify, advertise, or otherwise make anything known. B, visible from the public place, public right-of-way, parking area open to use by the general public, or from adjoining property. And, for the purpose of this clarification, examples of items that are not classified as signs, but are not limited to works of art, which, for the purpose of this definition, a work of art is any item expressing creative skill or imagination in a visual form, such as a painting or sculpture, which is intended to beautify or provide an aesthetic influence to a public area or area which is visible from the public realm and which in no way identify or specifically relate to a product or service. 2, architectural elements incorporated into the style, function of a building. And 3, flags, emblems, or insignia of the United States, Commonwealth of Virginia, which is not about art, but things that we're not going to get into the regulation of how big your flag is. So it's always going to be subjective, and someone's always going to have to determine whether the sign, or this thing that shows up out there, meets this kind of C1, is a creative expression, is not relating to a product or service. We do have maybe one in the county now that is a beautiful mural, but might have the name of a business on it. So, that would not pass this, and that person would have to think about what they want to do and might have to eliminate the name of the business and put a general phrase or just have no words at all. But that allows you to have the words like "Welcome to Sperryville," just not "Welcome to the Sperryville Emporium." Yeah.
Well, do we need a motion to move on, or can we, because I agree with Ms. Smith and Mr. Whitson here, I think that we can just, I feel comfortable with the way that it is right now, and I think we should just kind of roll it into the rest of the decisions we've made so that we can get to
Which
public
is
hearings.
inherently already rolled in if
Yeah.
this is
Yeah,
what you want, and I think, Art and I can look at it 100th time to make sure we're comfortable that there's enough black and white to help a zoning administrator in something that is truly a subjective topic and always is going to require discriminating inspection of the situation.
it is true, because, I mean, the one that Tom Mulaney did in Culpeper, I mean, those kinds of things are a benefit to the community, and so it's a good thing to do. So I'd be curious to hear from the public. So, yes, I agree with Ms. Smith, we've talked about this a lot.
Yeah, and I don't think a motion is needed. You're not taking
Yeah.
action on this.
Right.
Ultimately, staff needs direction as to what will it be in the versions that are put back out to public hearing. And so if this is similar or consistent with what you want, maybe a little opportunity to tweak if we think there's better language out there but that we've seen recently. This has
Okay.
been out there for a couple years now.
Yeah, yeah.
And is the idea then that on these individual elements of the overall ordinance, that they'll all be consolidated in draft form and we'd have a single public hearing for the whole?
Yeah, they are. I've been incorporating them along the way, and so the version that's attached today, and I've named it, so signs, temp and off-premises animated done public art murals box. So this version includes all those other things that you've already talked about. The last one that is left to talk about really is the regular signs, which goes back to where do you want them, how big do you want them? And do you want to differentiate with sizes or anything
Oh,
like
right,
that?
okay. Other than temporary signs. Yeah. Okay,
And so that would be the last topic before it's all pulled together and maybe the planning commission then looks at it all together, make sure there's not any confusion, internal reference, and staff will too. Make sure that everything's pointing to the right internal reference and put it back out for public hearing.
I still tell people how funny it is. We had that one night, we had that protracted discussion about temporary signs, and you made the obvious point that they're never allowed in the VDOT right away, and then you made a call to VDOT, and we solved the problem the next day. So we could sit here for months and argue about what our ordinance should say, and yet, you know, sometimes there are much easier solutions than regulating through ordinance, like make a phone call. And, yeah, I just don't wanna like go too far down these little,
Yeah, I don't know about you guys, we've talked about this a lot, and I would love to see us get this done before the end of the year.
Totally agree.
sure,
Right there with
That would be lovely.
we'll call it the
Since
Carney,
Reed v. Gilbert,
We'll
we'll call it
2015.
the we'll call it the Carney ordinance.
10 years, yeah. Oh, well, Ms. Smith has worked on this forever.
Yeah, all right.
Yep, sounds good to me. You got all your,
I think the first meeting I can remember, Diane was there too, and it was early 2020 where we took this up.
Oh, gosh.
2020, it's only been 4 years.
Well,
Well, we weren't Johnny on the spot with the 2015.
nobody can say we don't care.
This is Rappahannock after all.
There's a helpful little memo from LGA on enforcing sign ordinances that just read it before.
Oh, excellent.
So
Thank you.
I found it helpful.
Thank you,
Okay,
Thank you.
thanks.
thank you. All right, sounds like we can move along now to the courthouse project, continued discussion.
Madam Chair, I can get us started.
If you'd like.
Yeah, unless you have a specific,
No, other than we met with Gave and Holmes, they answered all of our questions for the, I don't know how many times.
sure.
The right number is the number of times you ask.
Yep, so we're here today to continue the discussion.
Sure, and, you know, it's August, so obviously a lot of people are gone. And most notably and unusually, there are no town residents here, as there have been at prior meetings when we've talked about the courthouse. And no doubt they'll soon learn about what I'm going to say. But it would have been good if they had been here. I've been thinking a lot about this project and the cost and the potential burden on our taxpayers. And I want to be as succinct and organized as possible in at least placing on the record, if not stating directly to more citizens than are here tonight. And certainly there are some key citizens with a vested interest in the courthouse project here tonight. So I've whittled down my position to this. I think there are absolutes that we can all accept, more or less. There are some assumptions that we are making. And then finally, through those, I've kind of clarified in my own mind where I fall on all of this. And I want to note at the outset, of course, I'm only one of 5 votes. So take my position for what it's worth, but I at least wanted you all to know where I currently stand. So in terms of absolutes, I think we're out of time. We need a new courthouse. I tried hard to hold tight to the idea that we could expand this one, and I think very reasonable people in a very reasoned way talked me out of that idea. And so I've moved on, and I understand that we need to build a new courthouse. So that's absolute. And we know that it's going to cost a lot of money. And in part, it's because certain of our predecessors, for whatever reason, going back to even the 1970s, and Mr. Luke's father and his colleagues on the Board of Supervisors chose not to take on a big capital project, but instead patch together what they could here with this building. And for their fiscal restraints and conservatism, I'm grateful. Our county continues to look like it did 100 years ago, and part of that is through careful fiscal management. Another absolute is either this board or the one to be seated in January has got to get this project done and final in whatever form it finally takes. Otherwise, and Judge Clements will be the first to remind us, we'll be faced with a writ of mandamus from the state, and then we'll have less control over the process of building this very significant, if not the most significant, capital project in Rappahannock County's history. Another absolute, and I say this as I look out to Ms. Grigsby, there will be a burden placed on county taxpayers, and that's no matter what we do. This isn't going to come at no cost. And it's sort of a fuzzy absolute for me, and Ms. Bruce, I think, if I read her body language correctly at our last meeting, doesn't agree this is an absolute, but it seems to me from listening to the judges and clerks who've sat with us for months now that we do need 2 courtrooms to accommodate 3 courts. And it seems like the count of the day count of court activity is somewhere in the range of 130 days per year. So 130 days a year of court activity across the general district, circuit, and juvenile domestic courts. And so I think just looking at it from a common sense perspective and a caseload perspective, I can see where the 2 courtroom configuration is reasonable and not excessive. And I don't want to be in the business of what they did in Loudon, we finished the project and it's already too small, out of date, et cetera. All right, so those are the absolutes. Those are the things that I think more or less we can all agree on. And then I was inspired by one of the 3 mayors, Mayor Sullivan, last meeting, who said from his business life in the Atlantic Publishing Group and elsewhere that he learned to question basic assumptions. And so I thank him for that inspiration, because since he said it, I've forced myself to question some of the assumptions that I think we have all made. So one of these assumptions is that the courthouse should be aligned with the other buildings on Courthouse Row. It should be built with materials that make it look like it's been here forever, and that it should fit somewhere into this town of Washington. And another assumption is that no matter what, in the end, whatever we decide to build, whether it's the current plan that we have before us, that whatever we decide, whatever we approve, will be subject to review and approval by the town's architectural review board. Mr. Luke, I think wisely said, I urge you to maintain a good relationship with the town government because you're going to need them, and that is maybe true. I'll call it an assumption that we're going to have to go that route. And I think a key assumption is that this courthouse is going to be built in the town of Washington. And I think we've gone a long way down the path to make that assumption almost as though it seems like an absolute, but I'm still going to question it for the sake of questioning it. And the biggest assumption of all is that the entire cost of whatever we build after a bond is issued and we amortize the debt on it over 20 or 30 years, the assumption is that that entire cost burden is going to be borne solely by Rappahannock County taxpayers in the form of call it a 10 or 15% increase in their property taxes. Okay, I think that assumption is that Rappahannock County taxpayers are going to shoulder it, and that's the way it is. And so now it's our job to make it as inexpensive as possible to lessen the burden on them. So with those absolutes and those assumptions, I just want to tell my colleagues tonight in this somewhat neutral meeting when we're not deciding anything other than talking about this further, my position. And my position is that I am eager and ready to vote with you all to get this project finished. But in doing so, I ask for your consideration of a couple of things. One of them, I said today to the school superintendent, I do think that we need to provide our taxpayers breathing room for a few years so that this tax burden that we assume will be borne by all our taxpayers in the form of a levy on their property tax rate is less. So we need to provide them some breathing room. And I know that I sound like the bad guy when it comes to the schools, but I'm willing to accept that label. And you all know my position that whether we're looking at fiscal year 24 funding at 9.5 million local transfer to the schools or fiscal year 25, which was 9.95, I think somewhere in there, if we can lock in our funding to the school system, as I said to Dr. Grimsley this afternoon, instead of us backing into whatever number the school system decides it needs, that we tell the school system what it is that our constituents, our taxpayers can afford to transfer to the schools. And I believe that this end of fiscal year 24 number of 9.5 million would be a good place to lock in and freeze school funding. And I'm just saying for argument's sake and discussion, and I have no doubt there will be argument and discussion as soon as I'm done in a few minutes here. Freeze funding at that level until June 30th, 2029. And that says to our taxpayers, we get it. This courthouse is a big deal. The related debt service means that your tax rate is going to go up no matter what. But we on the board understand that there are some safety valves, and one of them is to say to the schools, we need you to dig deep for a few years and work with what we can afford to transfer to you. The other key area that I want you, my colleagues, who I respect you all, I appreciate you all, I need your support on this one. And this is ultimately the question I raised during budget season. And it comes down to the fact that this town of 100 and a handful of people has a wonderful business at its core, the Inn at Little Washington, that is generating an extraordinary amount of money for this little town through meals and lodging tax receipts to the tune of $600,000+ at a tax rate of 2.5%. While I took personal criticism from the three mayors and their friends in the town for even asking the question of whether the town would consider at some point in the future raising their tax rate from 2.5% to 4% and sharing with the county the revenue generated from the additional 1.5%, which would be close to $500,000 under current economic conditions. While they criticized me, while they made it personal, while they called me out in the paper, I have not encountered a single person other than that small group of people in this little town who have said to me that what I proposed was in any way a bad idea. And so I want to renew that request for consideration to the town government. And I ask them to consider that same scenario I laid out back during our budget season. And I put that request out there respectfully, and I put it out there recognizing that the Inn at Little Washington and Patrick O'Connell is a great institution built primarily on his vision and his creativity, but recognizing that the relationship between the Inn at Little Washington and Rappahannock County must be always a two-way street. because without our county, the way it is, the Inn at Little Washington is not what it is. And so my very modest request on behalf of my constituents at large is that this two-way street relationship with the Inn at Little Washington narrowly and the town more broadly is in fact a sincere, real two-way street where there's give and take. And I hope that the town government will see here an opportunity to say that, yeah, you know what, we will consider asking visitors to this little town to pay into a Rappahannock County, call it a Rappahannock County Infrastructure Fund, which would be at the bottom of all the meals and lodging tax bills, or all the meals and lodging receipts issued in the town of Washington. And if we can, whether it's me, and maybe I'm not the right person to do this outreach again. I did it in writing last time, so it was very public. But if I could count on all of you to consider trying to initiate a discussion with the town in this regard, I think that it would send an awesome message to our constituents in each of our districts that we are trying really hard, as Sheila Grussinger said, to find money out there in the hills and the woods and the valleys, and we don't have to look much farther than this little town. And if we can succeed in some agreement with the town, I want to be clear what it means. Mr. Curry did a schedule on debt service, and if we were to build a courthouse that required a bond equivalent to $16 million, just pick a number, that'd be about 5 pennies on the tax rate. And under this arrangement, I've again proposed the tax burden on Rappahannock County property taxpayers would be cut in half. It would be cut in half with that additional revenue. And what I don't want to even suggest, but it's something that I do want to put out there, just to think about. If this courthouse is built down here, it means that for the 100-year life of that building, the town of Washington will be gaining revenue from the county in the form of sewer and water fees, 100 years worth, and that's not insignificant. I think that if we cannot reach a reasonable agreement with the town, then the question should be asked. I think that we should question the assumption that the courthouse should be built here. We have a lovely plan from Glavine Homes, and I have no doubt that that plan could be superimposed on an empty lot out on 211 somewhere if we got to that point. But I could imagine, much like Augusta County did, a binary choice in a public referendum that says, dear Rappahannock County taxpayer, the town of Washington, having decided not to provide any meals and lodging tax support for the courthouse project, Rappahannock County Board of Supervisors wishes to put to public referendum a choice. A, do you wish to authorize the Board of Supervisors to build a courthouse in the town of Washington with no local town of Washington meals and lodging support for $20 million? Or B, do you wish to build the Rappahannock County Courthouse outside of the town of Washington on an empty lot for some lesser amount? And if you look at the ultimately successful referendum in Augusta County, they set it up as a binary choice. A, more expensive in this location, B, less expensive in this location, and B, won resoundingly. So I just want to put all of that out there for discussion. I think an August meeting, when it's quiet, is a good time to put that on the record. Again, coming back to where I started, I'm with you. We need to do something. We need to get this project done. I'm not trying to walk away from it by any means. And I'm certainly not trying to start over. I'm just asking all of us to kind of question some of our assumptions and then to maybe do some uncomfortable, call it diplomatic, political work to see if we can't reach an agreement with the town. Because I think, based on the impassioned pleas from Joe Whited and John Sullivan and Caroline Anstey and others to scale back the size of our courthouse so that it fits the scale of the town, it seems like they really want this courthouse in the town. And if it's important to the vitality of the town, then for goodness sake, let's ask the visitors to town to pay for some of it. And that's all I have, and I really appreciate the time and for you all indulging me. Thank you.
Thank you.
Thank you, Kara, for very thoughtful, for your thoughts. Kara, I have a question for you. So we decided 2 years ago, I can't remember, I think it was 2 years ago. Donna, you weren't with us, to keep the building in here, and I think we voted on that. Or at least we voted, or we made some, I'm just saying, we talked about it. And we talked about, one of my very first meetings about not moving it up there.
We voted on things over the years that we ended up not doing.
Yeah, but anyway, the point is that, do you think that this is something like we could, Glavian Homes could say, oh, if we have an empty lot outside of town, they could say, it would cost this much?
If
Is it
there's
something
a,
easy to do?
I think if there's a general understanding of the lay of the land,
Mm-hmm.
right? We've done some geotechnical investigation here, so is there bedrock, is it a slope that would have a walkout or not? And so certain things would have to change. Right now, the lowest floor basement has some mechanical sally port, and that might have to be added to the back as a one-story thing. So I think with some assumptions, yes, they could.
Interesting. Do you have a specific piece of property you're thinking of?
I know everyone talks about the bank lots, and honestly, I just am putting this out there as an idea, but that's, for me, a logical general area, and there are plenty of empty lots, whether there's enough space there to take our current Glavian Homes project, and assuming that site preparation work would be significantly discounted for a flat lot. Speaking of assumptions, I'm making certain assumptions, but if we're not constrained by the ARB in town, and we're not constrained by the need to match building materials with Courthouse Road, arguably, we could look at other different types of building materials. We could get away from the excavation of a hilly site. But yeah, in general, that area is what I had in mind, and I know certain of those lots are quietly on the market. And I recognize there's land acquisition costs, but as I stated in my remarks, putting it somewhere else obviously would save us water and sewer fees. Now, no doubt you would have to do something on water and sewer if you put it somewhere else, and maybe that would be disadvantageous. But again, I'm just thinking out loud, and before we vote and sign on the dotted line, I just want to make a plea for revenue, and I want to make a plea for other ideas.
The other thing we would have to do is, I think, and it would just feel natural, if we were to do that, I think the Commonwealth's attorney would probably need to follow. So then we'd be adding that space. I mean, in terms of due diligence, I mean, the only reason I brought up that we had talked about it is because I do remember clearly having at least 1 or 2 meetings where we did talk about it. And I guess we all decided, hey, like, let's not go towards the referendum or asking the General Assembly.
Mr. Fraser definitely suggested it should be in Amosville a couple times, I think, in jest. And so I do remember that, and so I'm sure the conversation was had.
That's really good.
Yeah.
Pick a spot.
We'd love to have everyone that end of the county.
Culpeper and Fauquier pitched in, that would be very
I
helpful.
know, regional,
And I just want to say that I agree with Kira that, I think that there are some absolutes, which is that we need a new courthouse. It is going to cost the taxpayer money. That's just the deal. It's a core function of our government that we provide. That's how the United States and Virginia, this is how this is just set up. We do need 2 courtrooms so that we don't get behind ourselves. I think that that's clear. And that's because we have, expanded criminal dockets, we have really extended civil trial timelines, people just can't get trials. I mean, it's just booked out in advance, so there are some necessaries there.
This is awesome. We 100% agree with one another so far.
Yeah, I mean, these are things that I think have come out very clearly, and I think that the sticker shock is real. I am open to any conversation that you want to have with the town, that you go for it and have that discussion. I'm willing to have it. What I'm not comfortable doing, though, is trying to impose, well, we have no authority over them to do anything, but if you want to do a diplomatic discussion with them, 100%, I mean, I will talk to them.
Yeah, no, to be clear, we for sure don't have any authority, and we also cannot impose a county tax on the town either way because of,
I believe we've learned that if there is a town meals lodging tax, then it supersedes any county tax. If there isn't one, the county tax applies within the limits of the town. And I believe we've learned and still need to fully run to ground, with the permission of the town, there can be an overlay county tax.
correct, but it's by permission.
By permission.
Yes.
Yeah.
So,
Which could be a fickle permission if you're building that into paying your debt service, and it's good for 5 or 10 years, then in your debt service 30.
30, yeah.
Yeah.
But what I was going to say is that what I heard in our school budget discussions is that, most of my constituents prefer that the shared costs be spread. And so amongst the county, I felt like the meals and lodging with folks in the county felt targeted, and I had many discussions with them, and, I think that people really wanted the schools to primarily come from real estate. So we get into these larger discussions about where revenues come from. So I just want to say that we need a new courthouse. We need to do this. It's just going to get more expensive. It will never get less inexpensive. It's just, that's never going to happen. And so we need to jump.
Yep.
And to your point, whether we get a writ of mandamus from the circuit court or not, it's the right thing to do. So if you are having discussions with the town, I'm all ears.
yeah.
All the time.
Yeah, well, clearly.
And if you want to genuinely say, hey, does the county want a referendum? Would it be cheaper to put that out there? And I thought about this as well, but I felt as though and maybe it's just because it's in the town, but I felt as though people wanted it to look a certain way. And that does come with a cost.
Yeah.
Absolutely.
Yeah.
There are cheaper ways of building buildings. Not that we built a Morton building and have a court in there, but
I know.
But
At least a Butler building.
But it could be done much more cheaply, and I don't know that that's what the county wants. I'm not sure, but if the board feels like it's due diligence to say, hey, do we want to do a referendum? That goes down that path, and I don't know if we're there or not. I do think though that we've gotten to a pretty good spot with our needs, and I feel the architect said last night, and I truly do feel this way, that we're cutting bone, we're cutting limb.
Yeah.
There's no more fat to cut with the building. It does look nice. That does come with a cost, but it would be a 100-year building, and it does have 2 courtrooms. And I do think that we can get it down to 18.8, which sounds and is incredibly expensive. But I'm hard pressed to see how we can do it cheaper than that when you look at
Well,
other buildings that are half the size and almost as much.
yeah, I mean, I won't repeat myself about the one building that I'm very familiar with. But since then, I will share a couple things. Yeah, our due diligence, I've had a couple of constituents approach me and say, does it have to be in the town? And these constituents not only approached me and said, does it have to be in the town? They recommended spots, one of which is over by the bank. Another one is somewhere else. But so I think to be able to say that we did our jobs thoroughly, I'm not opposed to exploring this. What I think eyes wide open though, a couple of things. So I talked to, some of you may or may not know, I manage the heavy equipment operator program at Laurel Ridge, which means that I work very closely with some earth movers, and very closely with some earth movers who do this kind of stuff every single day. Every single day. You drive between here and DC, you're going to see their banners. So, I took it upon myself. I shared some of this stuff with them and talk to me, tell me what you're thinking. And the first thing that they shared with me was sadly, the 22 million was not terribly out of line. They did share, depending on who bids this, it could come down. Obviously, you wouldn't pick anyone if the price went up. They shared all kinds of insight with me. But something else that they confirmed, because we had mentioned this the last time, is that the year that I had tossed out, the last meeting was 2019, but post-COVID, since 2021, construction prices have gone up. The cost of construction has gone up by 30%. So I think it would be very reckless for us to not keep in mind that from 2021 till today, the $22 million courthouse that we're looking at, that it's $7 million more expensive than had we done it in 2021. The other thing, I think, again, it would be reckless as we do our due diligence and explore this idea. It would also be reckless to not keep in mind the same expert. I will call this person I spoke to an expert in building, not in courthouses or whatnot, but in putting boxes up. He said you can expect costs to go up by 3% every year from here on out. So that's another $630,000. And I meant to ask for this figure Friday when I met with Mr. Curry about just some other things, but I forgot. How much money have we spent to date getting to this point right here? So I do think that there's a danger. I think we have to keep that in the forefront of our mind. The other thing is, I agree, a good relationship with the town is going to be necessary. And I believe at the end of our budget season, when your idea first, when you wrote the letter and whatnot, I shared some constituents had contacted me and they had gotten behind that notion. And I said then, hey, I can get with you, but I'm going to hold your feet to the fire. So I think, the outreach should begin now, and we should be working on that relationship because of everything I just said. $630,000 a year. Is the board going to be talking in another 10 years about the courthouse that the judges have now made them build? And P.S., I spoke to someone who served on a board in another locality where that did happen. And now they have 3 courthouses because they maintained the one that the old one. They have the one that they were forced to build, and then that was built without enough forward thinking, the 2 courtrooms, whatnot, and they had to build a 3rd. So that frightens. I just think I'm all for exploring this idea, but it needs to be intentional. It needs to be deliberate, and if we do this to save $5 million in site development, but we've spent $630,000 times 3 years because we've waited.
I agree.
Like that, the scales start to tip.
We have to do a cost benefit analysis. And listen, I had lunch with Judge Clements, and trust me, she is the last person I want to upset. she comes with authority and has made it very clear to me what we could face if we don't make a decision. And I want to be clear, I'm not trying to stall, I'm not trying to avoid a vote. I just want to make sure that we run to ground every possible revenue possibility that's out there, of which we can all agree there are not many options. I don't want to beat a dead horse and say we're kind of looking beyond the obvious potential revenue source, and which is why I'm stating for the record that I believe we should renew my earlier request to the town. And it is not my goal to stall, delay, block, or otherwise derail our efforts to date, but I also cannot look at my neighbor, who I know is on a fixed income, as someone who personifies my typical constituent, and say to her, sorry, I'm gonna saddle you with a $400 a year additional tax burden, when, as she told me yesterday, when I explained it to her, she's like, yeah, I can't afford that. And so I'm just trying to whittle down that burden as much as possible. And I think Van is correct. The whittling down on the building itself, if we take as an absolute the 2 courtroom configuration, and we take as an absolute the other basics that the Supreme Court guidelines require in that facility, we're down to kind of not much else we can do on the footprint and the related cost. And so my instinct then is to go, okay, well, how else can we pay for it aside from putting on Floyd and Laura Grigsby or my neighbor Tina or others who I represent? And that's my job on behalf of my constituents. And I'm just saying to all of you, let's try to figure this out. And I'm not afraid to go to the town, and I probably won't even need to by the time I get home. I'm sure I'll have like red exclamation point emails from a couple of people telling me what they think about my idea. So that'll probably be an opening for me to continue the conversation.
Well, the way that I see it is that, you know, because we don't have authority over the town, and, you know, if it would be a win-win. Is there something that they would benefit from, that we would benefit from, and is there a creative way to do that? And how do we get there? You know, like, to me, as neighbors, and I know I keep hammering with, as someone who grew up in this town riding a bike around it, that's the way I view it. And I know that there aren't kids in the town anymore.
No, there are not.
But that's the way I see it, is reaching out and saying, hey, this is really expensive. Is there something we can come up with?
Yeah.
What can we do? What partnership can we build to bridge this gap? And so that's what I would feel comfortable doing. I mean, in terms of carrying on that kind of conversation. But I just want to say, though, that I do think we need to make a decision, because, and I don't know what that looks like. I don't know how we're going to button this up and say, okay, because here's the deal, is that we have engaged with them. They are waiting. It costs us money. We can mothball this. That will cost more money down the road. And when I say mothball, what I really mean is like even 6 months. Like, you know, so I think that we need to take a good, long, hard look, like not at this meeting, but in September when we come back to this.
By September, I think,
Where are we going?
by September,
Yeah.
I assure you this. Maybe by tomorrow. We will know whether this town government and the members of it are open to the idea of asking visitors to their town to pay 1.5% additional on their meals and lodging bills to support our county's courthouse. And either they're open to the idea because they want their town to be vital. They want it to have all of the elements of a county seat, namely a courthouse. And it is important to them to have a nice looking building that fits with what's already here. Or they'll say, no, we don't value any of that. I don't think they'll say that. I think they'll say, we do want the courthouse in the town. We do want it to be a county seat with the courthouse. We do want the building to look nice. And we do want input on what it finally looks like in terms of scale, materials, and all the little aesthetic stuff. And assuming that that's their position, then hopefully, maybe there's some room there for a discussion about what they'd be willing to do to support this from their visitors. From their visitors, not from them or from county taxpayers.
So what is this?
I'm remiss, Ms. Smith's been waiting, I'm sure
I'm
she's
sorry.
got some words of wisdom for us, Christine.
Oh, I don't know if I have a lot of wisdom, but I just wonder what a way forward would look like, and I'll defer to Hampton District Representative about what that way forward would look like, whether it would entail a joint meeting possibly in the near future. But I would be very open to that, and I do think it is time to start engaging with the town. If we are talking about the possibility of building in the town, to start to engage whatever appropriate body, whether it's town council itself or the ARB, to see how to make headway, to get a more definitive scoping of the project. And I would just mention, I know we don't talk much about the historic buildings on the campus, and I know that there's been will to sort of split the project. I think there's still a lot of the people in Rappahannock County that would like to see the historic buildings, and I want to say restored. I guess restored, repaired, and properly maintained, because a lot of them are in dire need of attention. And I know I've mentioned this a couple of times in our meetings, but Morale Calvian from the Department of Historic Resources helped with the historic courthouse complex in Leesburg, and she has indicated to me several times she would be willing to come speak to our board and help us with that, and possibly help identify funding sources as well.
Thank you. The one thing that I'm getting from tonight, thank you very much for your well thought out, it really was well thought out, is that we all seem to have come to the same conclusion about 2 courtrooms, and we need to do this. We can't wait. So that, to me, is big.
It's progress.
Yeah. What I am wondering is how much it would cost and how quickly they could do a just napkin figure on new piece of property, no water or sewer, you'd have to connect somehow, but no parking problems because it's a big field. Same building, that location. Just give us a idea.
I think it would be a redesign, because I think we would have to include the Commonwealth's attorney.
Yeah. Well, they had that originally, right? Art was kind enough
Or
to.
we just put that to them.
And that might, yeah.
Yeah. I mean, I would think we could get that in August, which would allow us, you don't think? It's a computer program,
This
isn't
month.
it?
There's humans pushing buttons.
I mean, she did say napkin drawing,
Yeah,
so.
yeah, we don't need
Just
anything
rough.
fancy, I mean,
The shorter the turnaround, obviously, the
The less
more
work.
assumptions and the more asterisks and the higher the contingency percent. On the back end, it's going to be, they'll say, yeah, I think it's gonna be $20 million plus or minus 50%. That doesn't give you any value.
the
you know,
$20 million
so-
would give us, I mean, that's
I
what,
was just a spitball
I
number
understand.
saying, it's a meaningless number because they don't have the precision to put to it, is the problem, unless you're, this estimate that you have now was prepared in great detail by the cost estimating firm for this specific concept on this specific parcel,
Yeah.
recognizing a lot of specific,
Yeah, thank
you
you.
know, things. And
A lot of specificity.
it would be very difficult to compare that to a cost estimate that is, well, typical construction is X dollars a square foot, and we don't really know what's underground, and we're just gonna have to guess about the water and sewer. It's gonna be difficult for those apples and oranges to really be able to have a comforting comparison. You can eventually get there if you say, well, that's compelling, it's within an order of magnitude, let's now dive deep, and then you might get to the end of the pipe and find out the number is less, more, the same, and have gone through that process. You'll have learned a lot.
Yep. And it's also an answer that our citizens really may want to hear.
Sure.
Would a building this size require a water treatment plant of its own?
It will require a permitted water supply like the schools have, or
Yeah.
some of our
But I meant,
lodging places.
but I meant like, not water, but like.
You could have a sprinkler
effluent.
system.
Well, it's gonna, obviously gonna be a well-based system, there'll be possibly treatment depending on the quality of the water from the well. Hopefully you have water coming of adequate.
I mean, instead of a drain field.
You mean wastewater treatment?
Yeah, wastewater treatment. Would I have to have a wastewater treatment plant?
Yes,
A
I mean,
small
it's just can't have just a septic tank and a drain field, so
Right.
it's gonna have
Right.
something more than that.
Right.
And then, you know, you get into questions, are we near one of the schools? Is there a way to, you know,
Yeah, yeah.
you know, it's just, we start really going down
Snowballing.
big rabbit holes.
I mean, I do like the fact that you don't have the utilities you'd have to worry about, that you're gonna be, you know, redoing back here because we're so close to everything else.
And the
There's-
other tricky thing is fire flow sprinkler system.
Yeah.
You're gonna
Use
have to
the
have a
pressure.
reservoir
Yep.
and then a pump.
Yep.
So you need to have a well, puts into a reservoir, a tank of significant size that would then be used for a sprinkler.
But I mean, the bank is there, and I know
Sure.
the bank is in a courthouse, but the bank's also not an insignificant commercial building.
I agree with Ms. Smith that if the town council wants to have a joint meeting, I'd be happy to do that. I just want to be very clear that the place I'm coming from would be a place of partnership. We have a vested interest together with the town to make this project work. And
I
so,
prefer it be in the
That-
town. I prefer it be in the town.
so I just want to make clear that that would be my goal.
Mine too,
So,
but
yeah,
but at the risk of restating the obvious, $30+ million in meals and lodging tax receipts in this little town. And all I am ultimately asking is that the people who come to this town and spend $30 million plus a year, paying an extra 1.5% into our debt service on the courthouse, so the people who live here and who have always lived here and who want to continue to afford to live here, be able to afford to live here, can do so. And I don't think that that would be such a bad overall plan to shift some of that burden off of our residents to the people who come out here because this is a beautiful place that we have managed really well, but with the fiscal consequences that come from open space and a relatively weak tax base. And I think it is an entirely reasonable idea, and I have, as mentioned, I have met almost no one, other than a small group here in this town, who nobody objects to the idea, and nobody has said it was a bad idea. In fact, they say, of course, it's obvious. So, yeah, I get the partnership stuff. That's fine, but I didn't see a lot of partnership when I sent a really nice, reasonable letter and got called out by the 3 mayors in the newspaper. So while I'm eager to have a civil discussion, I also am serious that this request is a reasonable one and that reasonable people should think hard about it because it could be a perfect, as you said, win-win. And so I hope that the reaction this time around is civil and not personal.
Would there be?
Because a partnership requires two. And I have taken the high road from the first time I reached out on this point.
So would there be value if Mr. Goff and I prepared a resolution that tried to set out in the preamble, whereas the cooperative nature, ultimately providing an avenue for the board to request more officially, maybe with one voice, maybe it's split, I don't know, this notion of the overlay tax?
No, I don't want to do that. I think that if we're going to partner with the town, I don't want to seem adversarial. We have absolutely no power to
But
do that.
it's basically a request.
I know, but I think that if we do something that's more diplomatic, we'd have, first I should say this. This is our decision to make. We're not going to figure out the quote-unquote financing of this before we have to make a decision. That could take a long time. That really can. And so, but we need to make a decision on this now.
Part of the financing is a commitment or no commitment from the town so that we know what our
And they can
revenue
always-
sources are.
And they can always, let's just, blue sky and devil's advocate, they could renege.
I'm probably oversimplifying, but as I understand it, there's only been a letter to the town, correct? So I think there's been a letter to the town. To jump from a letter to a resolution would be, that is, you know,
You could take my letter
I think-
and you put it as a board request, and if it's.
I think
if you don't
someone
wanna-
shows up at town hall with a bundt cake and they say, hey, look, it's time to talk. It is really time to talk. This is, and just outline some of the burden, share some of those stories. Because, yeah, I have a kid going to college. Well, he might go to college next year. I can't afford, this is expensive for me. But you know what? It's going to be expensive for Mason in 10 years if we don't do something about it now.
Yeah.
So what is, how selfish is that? That we protect the cost to us and we don't think about, the ones that we're hoping to stay, like your kids, like.
Yeah, I mean, if
The-
this had been done in the nineties,
So-
it would have been a different
Right,
price.
so
I mean, that's
all I'm
one
saying is,
point
I think the
out.
next move, and again, maybe it's oversimplifying, is just asking for a meeting and outlining, this is what it really looks like. I'm
mean,
sure they know,
so-
but it's different when, I'm sorry to keep
No, I'm
interrupting
sorry.
you.
No, I was just gonna say,
But
so I
you
went out
talked
on a limb,
enough.
because I didn't feel like it was your burden to ask the town, it's my voting district. So I went out on a limb last time. And Van didn't call the political stunt, I apologize for mishearing you at the time, but, I went out on my own. So what I'm asking you all, by thinking out loud tonight, is whether or not you're gonna stand with me on this, because if you will, and we run this idea to the ground, and we get a yes or a no, then at least we tried. I'm happy to continue to do it on my own, if that's how you wanna proceed. If you wanna do it in a letter, or a resolution that, Van's already, shied away from the idea of us saying, we hereby ask that you consider providing us permission to impose a county infrastructure overlay tax. He doesn't want to do that, but maybe a majority of us do. I don't know. So those are our options. And if we need to come back and meet and take an action, so be it. Or if you want me to just continue going solo on this, I will. It's up to you. And we know that any informal outreach cannot involve more than two of us. So either you stand with me on some vote to take some specific action in the form of communication to the town, or you just say, well, call the 3 mayors tomorrow, or the 1 mayor. They all seem to have a vested interest in this, and it's a small group of people. And I could call the town clerk and I could say, hey, a couple of us would like to sit down and talk about this civilly and rationally. Or we could call a joint meeting with the town council and just hear directly from them whether or not this is even a possibility. So I could see at least 3 options, including what Gary just proposed.
Ms. Smith? Ms. Smith?
I'm like, I don't know where y'all are headed, it's hard when you can't see people's faces.
Yep.
But I do think that the time has come to have a mutual exchange of information and listening session, with the town council and or ARB. If they are willing to engage, I would make the motion that we ask staff to craft a letter to that effect. And, be willing to engage, either in the course of one of their meetings or one of ours. Perhaps ours have more AV options, for sharing information and, blueprints. But I think we're at that point.
Yeah, so with the way that you've, and the way you've crafted your motion, it's to have a meeting with them to kind of ferret out, communication moving forward and how we can work together. Is that correct?
I think it was to send a letter requesting
No
meeting.
action contemplated
Right.
in the meeting, just sort of
Right.
a listening and information sharing, and there should definitely be cookies.
Yeah, I'll second that motion.
The cookies?
So discussion?
Yes.
So Ms. Smith, is the motion for Mr. Curry to send a letter to the town clerk requesting that we, the Board of Supervisors and the town council and other town interested parties, whether it be the architectural review, I don't know, it's probably the same people, I don't know, that we convene a joint, whatever you want to call it,
Right,
joint discussion, public discussion, is that it?
right, that we host a joint information sharing, listening and discussion, session. I would say preferably at the current courthouse because of, the screens, that make it easier to display information and our staff's familiarity with that venue.
Okay.
I agree, just because I had wanted to do that a long time ago, and I think we had talked about it. So, I mean, we're at that point where it would seem to me if we didn't do it with that layer of government, it would just seem odd. We haven't met with them, and we are working with them. We need to. We need to work with the IRB. We need to do that. So, yeah, I mean, I think open communication is always a good idea.
All right, we have a motion and a second. Any other discussion? Timeline-wise, I don't know.
ASAP.
It can be a one-page letter. I mean,
Oh, yeah, be short.
Yeah, no, I meant the meeting, sorry.
Yeah.
You're end of August, early September?
Yeah,
Yeah, let's throw
I'm gone, yeah.
Yep.
So I would say the end of August.
Okay. You okay with that, Ms. Smith?
That sounds good.
Okay. All right, all those in favor say aye.
Aye.
Aye. Any opposed?
Aye.
Awesome.
Can you get Kringle?
Yeah. I'll order a bunch,
kids were talking
I'll
about
order a
getting
bunch of
dinner.
O&H Kringles,
Who's making the cookies?
and my son will get one.
Well, I mean, I think the town has some pretty
I'll get you
good
some.
Yeah.
cookie makers, right?
Dr. Donna was bringing fun cake.
Yeah, okay.
Okay. Thanks, Art.
Thanks, Art.
Thank you, Art.
All right, Sperryville VDOT concerns, Ms. Smith.
I had asked for Gary to put this on the agenda, or add this to the agenda, because the residents of Sperryville know their village so well. I have people frequently speak to me about their concerns on that connector street and the intersection in front of the corner store. And I mostly wanted to put the information out there that VDOT is working on the situation, and also reach out to you as my fellow board members. I do think if there's anything we can do as a county to support VDOT, not monetary support, but if there's any communication we can issue to assist them. As you all are aware, that's already such a constricted intersection. And it was the site of, or it is the site of a VDOT project that the county took on, the Sperryville Gateway project. And so that red brickwork in front of the wall is paid by taxpayer dollars, I believe. So, just that we need to keep that an open, viable space for use by county residents and safe thoroughfare.
So I think VDOT has contacted the owner after obtaining their own survey, which there are several surveys for this corner parcel, and basically told the owner to move their wall. The conversations I've had with VDOT indicate that there are likely two outcomes. One is that VDOT, goes through the courts and attempts to force that to happen. Or they simply shift liability onto that owner, saying, well, if bad things happen, it's your wall, we told you so. And VDOT might have interest in if the board has a strong opinion on either of those outcomes or some different outcome. Not that they're beholden to your interests in this case, it's fully in their wheelhouse. But if the board does have a strong position, or no position, that would probably be valuable for them to know.
And at what point, Gary, does it become vested and not something that VDOT can ask for?
I don't know that, that's a legal question, Art left. I don't know that an encroachment to the right-of-way is ever necessarily vested. I think it's once an encroachment, always an encroachment. Now, the nature of surveys is the current survey is the survey until the next survey shows a different line. And maybe that's what the Thorsons are doing right now, commissioning yet another survey to say, VDOT, you got it wrong. Because it is a little bit complicated there with the curves and where the line actually is and what the radius is and all that. I can't tell you. But I don't think it's ever vested, other than if it's been 20 years and you go to court, I suspect that it's harder for VDOT to say, this is really dangerous, and nothing's happened in 20 years. The judge's probably gonna look at that and say, well, that doesn't sound very dangerous to me. But the Office of the Attorney General is, I imagine, pretty well versed at handling these sort of things and identifying which need to be vigorously prosecuted, or whatever the right word is, and which maybe aren't worth that effort. And I was just saying that maybe they would take your thoughts into account if you have any.
Well, so we don't know what the VDOT letter said to them, do we?
Oh, yeah, I have them.
You
I
have?
didn't think it was appropriate to put them out.
Okay.
in the world, but-
Well, I would think though that if they're in the right of way and they resolve it, they will in court get them ejected, and VDOT would.
Maybe.
Trust me.
If they choose to do that, there's cost and time for the
Yeah.
OAG's office to do that, and for a fraction, from no feet to a fraction of feet to 1.2 feet of a 2-foot wall, they're gonna decide at some point in time whether the juice is worth the squeeze.
The great Gary Curry's great quote. Now use my copy.
So Christine, are you asking the board to do anything in particular, or is this informational? What would you?
It was mostly informational because I get asked about it all the time, and I imagine you all may have heard something about it. But I guess we'll wait and see how it progresses, and if it is beneficial for the county to send any kind of communication, I would ask that you think about that. And if you haven't, drive through there, especially during the daytime when it's an active construction site, there's a lot of vehicles parked in the vicinity. it's really, it doesn't seem like a lot of space, but that's such a narrow, intersection already. It really hasn't, I think, affected the intersection.
All right, thank you very much. And,
Thanks.
So there were two other points here, and that
Oh.
one is the parking, and we do have a county code that prohibits parking on sidewalks. I know that we haven't come anywhere near this in the 7, 8 years I've been here. And I would guess if you went and looked, you might find that you've never prosecuted anybody for parking on a sidewalk. I backtracked our code to state code and scratched my head and looked at it sideways and thought, I think Art needs to probably read this to make sure this is something we're really allowed to do in these areas. So if the board has any thought on whether you,
I mean, the delivery
Would ever
people are
want to-
parking on sidewalks.
what's that?
Delivery people are parking on sidewalks.
Yeah.
Well, I think there's a difference between people parking on the sidewalk for half an hour and making their delivery and going on about their day. And, some of these places have been active work sites for a year or more. And work trucks parked on public projects, funded with taxpayer dollars every day, all day. And, I come from a working class family. I know what it's like to make an honest living. And there is certainly a long time where it was tough to park on that site. I think those days have come and gone, and I think people can pull into that site now and reasonably park in the parking area and no longer be obscuring the public sidewalk. But I do understand that a valid legal position is important.
Yeah, when I went through the other day, when I took that photo, there weren't vehicles there. And I think that this issue is largely cleared itself up based on where they are in construction, but it will come up again somewhere. And I think it's worthwhile to have Mr. Goff make sure that that code is firm. And then, if it is, then what is the process that you would want to go through? Who's citing and all that?
Yep.
And lastly, across the street, the former owner put this entrance in without any permits from anybody. And VDOT has contacted them as well and said, that's not allowed. They have restrictions on corner clearances and how close you can have these sort of things. And I think VDOT would want to know whether you feel strongly about this too, and whether you want to force them to yank it out with jackhammers or block it off with a nice planter like they have around the corner. If the board has an opinion, it would help VDOT. If you don't, then VDOT's going to have to do whatever they think is most appropriate from a transportation perspective.
I think the most important thing here is if the answer is that it's to be obstructed, then it needs to be obstructed in a permanent way, not in a way that would encourage someone to get out in the turn lane and move something and then pull in.
Yeah.
Because as the problem here is that it's a turn off and encouraging people to back out into a turn lane.
Several 100-pound planter or bollard.
Incredibly dangerous situation.
Yeah, and just to be clear, this was not the current owners, this was the owner before.
That's correct.
Who
But
did,
agreed.
Okay.
so, VDOT is tracking this down and doesn't require an input from the board, but if the board wanted input, now's a time you could provide that.
Yeah.
Well, ever
I was
since-
putting that for informational, because people do ask about it all the time, and this is, this is public information that they have a right to know and know what agencies are working on to help them.
Good information.
Thanks a lot.
Thank you.
Enjoy the rest of your trip.
Yeah.
Thank you.
Have a good time.
Yep.
Motion to
What?
Motion to adjourn from me, please.
Wow, not Van?
Not Van.
Second.
I know.
All right, motion to adjourn. All those in favor say aye.
Aye.
Aye. Any opposed?
Bye.
Thanks, Christine.
Thank you.
Thanks
Enjoy
for
your
dialing.
trip.
Thank you.